Hi there, it's Catherine, your lawyer friend and guide, and this is the #1 podcast for legal careers in Japan. Thanks for stopping by the Lawyer on Air podcast. When I asked my guest on this episode, Earl Rivera-Dolera, what her motto in life is, she told me it was the quote from Theodore Roosevelt's Man in the Arena speech. He said, "It is not the critic who counts, but the person doing the work, taking the risks, and daring greatly." Brené Brown herself has given a modern take on this idea, saying, if you are not in the arena also getting your ass kicked, I'm not interested in your feedback. Wow, that's amazing. A powerful reminder that criticism from the sidelines is super easy, but the real courage lies in showing up and doing the work. Well, this chat with Earl got me really thinking about how often we face unsolicited opinions, micro criticisms, and that good old armchair commentary from people who have, frankly, never been in our shoes. In the moment, though, it's so hard to know how to respond. Do we push back, ignore it, laugh it off? Well, in this episode, Earl shares her perspective as a highly experienced arbitrator, someone whose entire profession is about understanding different viewpoints and handling tough conversations with grace. For me, I have to admit, it was the school of hard knocks that taught me handling criticism with confidence, not defensiveness, can make all the difference. Try to redirect your comment with your expertise. You can say something like, well, for me, it's always valuable to hear from people with direct experience. How have you handled it in the past? This is gold because it flips the focus to them and flattens out the confrontation. Recently, also, I countered with this one. Hey, I appreciate your sharing of your perspective. The reality is, though, that this work is quite different from the outside looking in. But you know what? I really hope this conversation we've had just now helps you if you are ever in the exact same position in the future. This one again turns that spotlight back onto the critic. So how can we avoid jumping to conclusions and making snap judgments? Well, Earl has some brilliant insights on this about leading with curiosity and not with criticism. And I know you are going to love hearing her take. So let's get into it. Here's my conversation with Earl Rivera-Dolera. Hello, Earl, and welcome to the Lawyer on Air podcast.
Hi, thank you for having me.
I like to start with a warm-up question. So imagine we are out for a drink or coffee together. Where are we and what do you like to order?
We will be somewhere with a view of the Marina Bay Sands in Singapore, perhaps. I am in Singapore currently. Or somewhere just, with a view of the waters around Tokyo, in a coffee shop and having some coffee and some desserts. I have a sweet tooth.
Ooh, sweet tooth. I love it. There's so many things around Tokyo right now as we're recording strawberry season. There's so many hotels are doing strawberry buffets. And so what kind of coffee do you like?
Simple black,
Oh, me too.
with sugar.
Oh, you have sugar as well. Wow, you really love your sugar. That's amazing. It gets you going, right? You need something in your system. And I know too, when people are stressed, they often have a sugar in their coffee or their tea, even if they don't normally have it. But you're you love your sweet coffee.
Yeah,
Wow.
just one packet of sugar would do.
Okay. It's not too bad. Well, thank you so much for joining me today. I'm really looking forward to our conversation. We're going to be diving into your career path, your arbitration expertise, which is off the scale, and of course, your career experience in Japan. And I'd love to hear your career wisdom and some personal reflections along the way. You've had a fascinating career. It spanned multiple countries and legal systems. I want to go back and find out what first sparked your interest in law.
I used to read detective books when I was a young kid, Nancy Drew, Hardy Boys, and I was fascinated with, investigative detective work, and I thought I would be a detective. But
Really?
law is not far behind from it, especially in litigation or arbitration or in contentious matters. We have to do evidence gathering, fact gathering, investigate before presenting pleadings and evidence before a court or before an arbitral tribunal. So that's how my interest in law started.
So interesting. Isn't it true, though, that you're really an investigator or detective as an arbitrator?
When I act as counsel, lawyering for clients in arbitration or litigation or cross-border work, we do have to go through the evidence, the facts, the documents that's available, and investigate first whether indeed our client has a case or has a defense against claims against them. And then before we put it out and file a statement of claim or statement of defense before the court. So it all starts with investigation from the get go.
Wow. So you have made that connection between your early days of reading those detective books to what you're doing now?
That's true.
Wow, amazing. So you started out, I think, as a justice law clerk in the Philippines. Did you have
Mm,
ambitions from then to work internationally? And if you didn't, then when did that come up to sort of go outside of your own, I believe, where you were brought up, right? And go
yes.
international?
You know what? This is always a very good question, like to start conversations in networking events and conferences. My love story with international law or international practice practically started with a love story itself. I didn't have any plans to go out of the Philippines where I was born and raised. I was planning to become a judge and, retire as a judge, perhaps a justice in the Philippines. And I met my husband, who was also from the same hometown that I came from in the Philippines. And he was already based in Singapore at that time. And as a trailing spouse, I followed him to Singapore. Didn't know what I'll be doing there as a lawyer. So I studied again at the National University of Singapore. And that's how I met my very first mentor and teacher, Professor Lawrence Wu. And that's how I started my career in arbitration. He kindly invited me to join his chambers after my graduation at the NUS. So that was some sort of, I would say, really a good, fortunate event for me, good luck for me to be invited into his chambers. And I started as his law clerk and I started getting arbitrator appointments as well while I was there.
So you can be a law clerk or law clerk and then also get arbitration assignments?
Yes, for sure. When I started clerking for these prominent international arbitrators, I also started networking as well with the various arbitration users around Singapore. And you'll also be exposed to the various players, the claimants council, respondents council, the arbitral institutions like the International Chamber of Commerce, Singapore International Arbitration Center. And that's how I started getting my first set of appointments as arbitrator.
Oh, that's really interesting. Can you share something quite memorable that happened in those early years? Maybe it was even through your networking, something that struck you. And getting out networking is obviously extremely important in those early days. Something that popped up that you can remember now from those early times.
I would say my very first arbitrator appointment led me to India, which was the seat of arbitration. So that's where the hearing was supposed to be held. And I did hold the arbitration hearing there. And I was sole arbitrator. So it was just me going there and appearing before counsels. And as you know, in arbitration, all the procedure, the process, and the steps leading to the hearing are mostly done online. And then the first time you'd see all counsels, the witnesses, experts would be at the hearing venue, at the hearing dates, which will be at the tail end of the arbitral process. So when I went to India, that was the first time I saw everyone. And I entered the hearing room, bringing my own suitcase filled with documents, all the hearing bundles. And both counsels who were older than I was at the time, and still older at this time, I guess, they were quite senior already. They didn't know whether to stand when I entered the room and, give me some greetings. So I told them immediately, yes, counsel, I am your arbitrator. And
Oh,
they immediately stood up and,
oh,
and addressed me as they would address a court in India, like your ladyship. And I just
thank
told them,
you.
no, just call me Miss Dolera, and I'm fine with that. But yes, I am your arbitrator. I think that was kind of funny in a
Very
way. Um,
memorable. Great
Memorable, very
story.
memorable. Yeah.
Great story. So they didn't think you as a female, am I right here in the
Yes.
room?
Yes.
And you don't wear
Mm.
anything particularly that addresses that you must be a judge or an arbitrator. You know, you're not wearing anything in particular that is an indication of you being the arbitrator.
No, not at all. We wear our usual business suits in arbitration hearings. But of course, we've corresponded over emails during the course of the arbitral process leading to the hearing. But I guess because of my name, it's Earl, it's commonly a male name. They didn't
Right.
realize that
Yeah.
I'm female.
Right. So you'd been online, but they hadn't actually seen your face.
Yes. I'm not
Uh-huh.
sure if they Googled as well. It's usually like people
You'd hope
would
they
Google.
would, as
I would
particularly
have hoped so.
as good counsel doing due diligence on the arbitrator, you would hope so. But that's a very interesting story. Goodness me. So you've done a lot in this area. What actually was the key thing that attracted you to arbitration? You talked about the detective books, but what is it about
Mm.
arbitration that you love?
As a trailing spouse to my husband then in Singapore, I was already a lawyer in the Philippines and doing litigation, court litigation in the Philippines. I knew back then that I couldn't just go into court litigation into Singapore without being qualified as a Singapore admitted lawyer. And then I studied more on international business law, international transactions, and that's how I got into a course on international commercial arbitration. And my professor then became my boss. And that's how I realized that, hey, I can go into arbitration without going and studying again a JD program and be admitted into Singapore as a qualified solicitor. It's something that any foreign lawyers can do wherever you are situated, wherever you are located. And at that time, Singapore's arbitration scene was really up and coming and really booming already around 2010, 2011, 2012. So it was a matter of being at the right time, the right place, and with the right mentors, I would say.
Yeah, what do you think it was that Professor Wu saw in you that he thought you would be good for arbitration? Because I'm sure as a mentor, he would have said, hey, I love that you're interested in, but you need more of this. But he must have seen something about you. What do you think that was?
He didn't really tell me anything. He's your typical, not doesn't really give a lot of compliments, but I understand that he would say those compliments outside of my earshot. So I was told that he wouldn't really give me compliments at the time, so that my head wouldn't grow bigger.
Yes,
Is that like
yes,
the idiomatic
yes.
expression for
Yeah,
that?
get too big. Yeah, exactly.
Yes,
Yeah.
but I would just hear it from friends, colleagues, or those who appeared before him that he appreciated what I've been doing at the time, clerking for him.
Right. So, for people who want to get into arbitration, do they need to be, what could I say, unafraid of debating or unafraid of negotiating? Are there other skills that they need to have to be a useful and really competent arbitrator? What's your thoughts on that?
Acting as arbitrator, I would say someone who is not afraid to be decisive, someone who could steer the procedure efficiently and as speedily as possible, but without sacrificing, of course, due process considerations. Arbitration is a continuously evolving area of law. What could be applicable this year would be already inapplicable next year. So there's just a lot of changes almost every year. So someone who's also easily adaptable, who are updated as to the developments of various arbitration laws that would be governing your arbitration if you're appointed as arbitrator. I guess it's the same way when acting as counsel. There's continuous learning. You cannot just be resting on your laurels just because you've been appointed arbitrator a number of times already. My mentors in arbitration, I would see them continuously learning, attending all these seminars, all these webinars as to developments in arbitration in Europe, in Asia, in the Americas. And as counsel, I think that is also very important to continuously learn about arbitration. And I would appreciate a counsel who is also relentless. Clients come to us, especially when they're in deep trouble, and they want solutions. And sometimes those solutions that they want not exactly what is applicable under the governing law or may not be granted to them under the governing law. It's our job as counsel to show to them and be relentless in showing to them that this is what could be allowed under the law for you. But we need all these evidence, we need all these documents. So someone is really relentless in doing and not lazy at all.
Absolutely. Wow. Talking about that international experience you've worked in Singapore, as you mentioned, I think also in Vietnam, and now you're in Japan. What have been some of your surprises in these jurisdictions or your learnings, perhaps? Maybe starting from Singapore or wherever you would like to go.
In Singapore, counsel in arbitration could really focus on just doing legal work, really focus on reading the law, researching the law, and writing all these pleadings, evidence gathering, and showing in the writings how the facts are indeed in favor for your client in relation to the applicable law. Going into Vietnam, I knew back then that there would be some challenges. The legal framework may not be as robust as one would expect from a mature hub for arbitration such as Singapore or England and Wales. And that was, I think, the major challenge that I met there. You'd be faced with problems from your clients, and going into Vietnamese law, it might not be covered at all because there's just no legal framework covering such a problem. So that was the big challenge right there. And then now in Japan, where you have a legal framework that's so robust, but at the same time, the culture may not yet be as welcoming to arbitration as they are for a non-litigious dispute resolution mechanism such as mediations. And I think the default dispute resolution mechanism in Japan is still court litigation. So there's still a lot of work to do to change the mindset of users of dispute resolution mechanisms that indeed arbitration is a more viable option, especially when they're dealing with cross border work and dealing with counterparties overseas.
So lots of technical stuff there on the differences between each jurisdiction. How about Earl herself in those different countries? How are you different or the same, perhaps? So how you operated in Singapore and Vietnam compared to Japan now, have you done things to modify your personal way or approach of being a competent arbitrator in those areas? Tell me a little bit more about that personal side of things too.
Well, thanks very much for that. As you know, when we act as arbitrator, we rarely have this opportunity to show our, real selves, authentic selves, and personalities. But there's a lot of adjustment that I would need to, go through in Singapore. Acting as counsel or acting as arbitrator, it's more direct and straightforward, I would say. There could be some cultural nuances right there, adjust to the way people write their pleadings, adjust to the way they advocate. It's more polite in a way in doing oral advocacy and arbitration in Singapore. Going into Vietnam, the level of debate I was told is really kind of personal, and it's common that there might be shouting in the arbitration room or in the hearing venue. And indeed, I was part of a case. I was lead counsel in a case where my opponent was practically shouting at me, my opposing counsel.
Oh dear.
Indeed. And I would say I get that because his client, the CEO of the company, was with him in the hearing venue. And, there might be some strategy right there where he wants to impress the client with some theatrics.
Yes.
But at the end of the day, having done this for more than 10 years already, my superpower is my calmness. I give them a smile when I'm so calm in the hearing venue. And then I give them all the time to, whether they would try to shout at me or shout at the tribunal members, because even the tribunal members would be, shouting as well. To them, perhaps that might be normal, but there was a time at that my opposing counsel young ladied me, you young lady didn't know what happened to the negotiations at the time. Things like that. And
Mm.
I would be calm and say, first of all, counsel, I'm no longer a young lady. Think things, and then I'd go to the facts and the evidence and just, at the end of the day, especially that hearing, his client, the CEO, left the hearing room before everyone left because I guess he knew at that time that it was really a losing case, and we did win that case.
Very interesting. This concept of calmness is so critical for really good leadership. And I think it really shows up in a situation like that where it's contentious and you've got to keep calm. You
Mm,
really have to keep calm. And, bravadery and those sorts of tactics, or what did you call them? Theatrics. I love that word.
theatrics. Yeah.
Yeah, it just doesn't work. So Japan's a different situation again. Maybe it's not direct and not straightforward like Singapore. Maybe there's a little bit of indirectness there, and perhaps you're still bringing out that superpower of calmness to its maximum extent. Tell me a little bit more about Japan, and perhaps going into as well how you found your role in Japan and why come here. What's your story, Earl? Tell me.
Yeah. For the Japanese market, as to your first question, Japanese arbitration users are quite calm in their demeanor, very zen, I would say. But at the same time, the type of communication is not direct, not straightforward. It's very contextual. But at the end of the day, when you appear as counsel in arbitration, it all depends upon the facts and the evidence being gathered. One thing that I have seen the Japanese market use more often are really handwritten notes, a lot of Excel sheets, really meticulous and very good at note taking reports that at the end of the day are really useful as evidence in arbitration, what had happened at the time. Contemporaneously prepared evidence and documents. And I find that very useful indeed. I was part of a case where one of the witnesses offered as evidence all the contents of his diary, handwritten at
Wow.
that time. Yeah, at the time when they were negotiating a deal, which was the time where I think the breach of the contract had happened or any fraud of that contract had happened. And that was accepted in the arbitration because it was a contemporaneously prepared document. And I think that was fascinating for me because, who would be preparing handwritten diaries at this time? And that's their one in, I don't know, 100 in a million, I guess. As to your second question as to why Japan, arbitration is growing a lot in Japan at the moment. There's a lot of arbitration practitioners who've been part of capability and capacity building around Japan for arbitration to be accepted more and to be used more in their contracts. When I was in Vietnam, I was dealing with a lot of Japanese companies as our clients. And I'm proud to say I had won all of those cases where we're dealing with Japanese clients. And I think that was the way where I got connected with some recruiters in Japan and got into talking and discussing as well as to, transferring and moving to Japan and grow the arbitration practice of Tokyo International Law Office.
Yeah. Had you ever visited Japan before?
Oh, yes. I think more than 5 times already.
Okay, so you were
Um,
familiar with it.
yes, yes.
Yeah.
At that time, when I was still based in Singapore, and even when I was based in Vietnam, there would be arbitrations that we do in Singapore with Japanese clients or Japanese parties. So I've had my exposure as to Japanese way of doing arbitrations already at that time. And I'd be also visiting Japan for events, conferences on arbitration, and had spoken to a number of conferences and events in Japan at that time. And I wish to highlight, I acted as arbitrator as well, where the arbitration was held in Osaka in the middle of COVID when the borders of Japan was still not open to tourists. And I had to get a special kind of visa when I was still based in Vietnam in order to go to Osaka to hold this arbitration.
Wow, I have not heard of anyone who was able to travel into Japan during those pandemic times and be able to do that. Most of them were held online, so that's pretty special. I loved you talking about your mentor, and I could hear you light up when you talked about him.
Mm,
Mentors are so important in our careers. Can you tell me, maybe it's him or another person who's walked across your pathway, who
mm,
may not necessarily be a mentor or defined as a mentor at the time, but when you look back, you go, I think that person was probably mentoring me and I didn't realize it. Have you had
mm,
any opportunities like that, or perhaps any lessons that you've learnt specifically that have stayed with you
mm.
from that mentor you mentioned before, your professor, or anyone else? I'm keen to hear.
Oh, very much so. I've been just so fortunate in my life and in my career, having met all these kind and generous mentors. And I would start from my law clerking with a justice in the Philippines, and her name is Justice Teresita Diliaco Flores. She's already a retired justice, but when I started my law career with her, being a newbie, being so, I would say, incompetent and not confident at all. But she was so patient in mentoring, in checking my drafts as a law clerk in the Court of Appeals in the Philippines. It took some time for me to be really confident and make a decision in my drafts and to discuss those with her. I was really shy when I started in my legal career. I was so shy in networking. I would never network at all in back in the Philippines. But yeah, Justice Flores was really instrumental in building up my confidence, not just my competence, but my confidence. She used to be, Commission on Elections commissioner in the Philippines. And as you know, the elections in the Philippines can be really dangerous for a woman. One of the good stories that I would remember her telling us was when she was down south in the Philippines in the island called Mindanao and having some press conference regarding the elections in that part, which can be really dangerous. And there was a bomb that detonated outside the building where she was holding the press conference. While she became so afraid, her legs were shaking at the time. But at the same time, she gave us a lesson of courage and bravery in facing those adversaries, especially in such circumstances. When I went to Singapore, of course, Professor Lawrence Bu, very much instrumental in my arbitration journey. And I knew that he would also, market me as someone who could be appointed as arbitrator. And I think that was very important. Another person that I would say was very much instrumental in putting my name out there is Andrew Moran KC, who's also a full-time arbitrator, but now has been appointed as a judge of the Dubai International Financial Center. And he's been really just generous in his mentoring and more so in his sponsorship. I think that's also very important. When a mentor sponsors you, your name is being attached to their name. and then gives it out to their contacts as someone who could be appointed as arbitrator. I think that's really important as well, the sponsorship part.
Yeah, I agree with you. So now that you're actually in a mentorship position in your firm with other, I guess, younger and other, even older, right, practitioners, what kind of advice are you therefore giving or mentorship, sponsorship to your people around you? Are you talking about patience and courage and bravery, which you just spoke about now, or is there other things that are maybe a little bit different coming from the Earl version of mentorship and sponsorship?
That's true. Most of my colleagues are already like the competent and confident persons that they are, because I think we've met at a more mature level in our career already. A lot of them would want to go into arbitration and do more arbitration work. My very practical advice, of course, is to gain more training from training providers. Is not just theory, but the practice of international arbitration. If we want to pursue this career as arbitrator or as counsel in arbitration work, it's very important to be relentless and not to be lazy in pursuing the pivotal justice moment for your clients. If a client comes to us for arbitration work, acting as counsel, they would want to see someone who would really fight for them. So if they immediately see the aura of a counsel who is already like, feeling like the losing party, they would not come to us at all. So they would want someone who they feel would really fight for what is right and what is just under the facts and under the law. Another thing that I usually tell my colleagues, juniors, it will be a long road ahead. A lot of patients would be involved in, increasing one's competence in arbitration, and at the same time, really relentless networking to the arbitration users around, and changing the mindset of everyone to use arbitration as their dispute resolution mechanisms. Because without that, there will be no arbitration work. As you know, arbitration is a product of consent, a product of contract. Without arbitration in the contracts, there will be no arbitration work. So we really have to start from that.
Brilliant. So you gain more training from training providers, be relentless, don't give up, look for that. I love that, what you said, the pivotal justice moment for your clients. Fight for them, and you know that it's a long road ahead. If there are lawyers out there or students coming through law school who want to break into arbitration in Japan, what advice would you give them? One piece of advice.
One thing senior lawyers would want to look for, those who would want to join as associates in their arbitration area of practice, is experience in mooting competitions would be highly preferred, because that experience provides a really good training ground as to writing pleadings, oral advocacy before arbitrators, and it's really a good training ground. While in law school, be exposed to arbitration or litigation clinics. Grab those opportunities when you could already do oral advocacy in courts, sometimes with a mentor beside you. And I think that's allowed in a lot of courts. We're really looking for those with exceptional writing skills and oral advocacy skills, because down the line, we would want them to do first share already and do lead counsel, lead advocate work, do the oral advocacy in arbitrations or litigations. And I think that's very important. At the end of the day, I want someone highly trainable, of course, without the ego, and very much interest in doing contentious work in arbitration. Because there's also some, associates or younger lawyers who would rather do transactional work and corporate work, and that's okay. Because without that interest, there's just no point in pursuing that line.
Yeah, that makes a lot of sense. I loved you said to be highly trainable, right? Trainable, able to be trained and without ego. And how does that balance out then with that relentlessness, not being lazy? So, what's the difference there? Can you be relentless without ego, or does some of that come into it? Probably a little deep question, but I'm interested to know because someone might think, wow, relentless. Okay, I've got to go for it. It sort of requires a certain amount of confidence in oneself, but maybe there's a point where it tips over into ego that's probably best not to have. Can you help me on that?
Mm.
Because it's really important for people to know, if you're going to hire a junior arbitration lawyer in your team, you're looking for these things. So I'd love to hear a little bit more about that point.
When I mentioned relentlessness, it's more of, yes, being aggressive in looking for the evidence, being aggressive in putting out all these facts and not being lazy as to, hey, this is what the client has given us. My idea of relentlessness is being aggressive in asking the clients for more, and not just accepting what the clients told us, because for all we know the clients do not know what they're looking for. So asking the right questions, being relentless in steering the client into the proper way of pleading, in the proper way of gathering all this evidence. In terms of being an advocate when we're already in a hearing and all of that, of course I need someone who's confident and relentless. And how do I reconcile these? I want someone confident, relentless, without the ego. If that someone could show that they're being relentless, has substance into it. Someone is just being perceived as confident and could be seen as confident, but there's just no substance at all. Then you know that ego is coming into play.
Interesting.
Someone, I would say, someone who's really confident is someone who has some substance to say.
If I break down what I've just heard from you, it's almost like what you do is relentless. You're aggressive, finding the evidence, but it's the ego part is who you are or how you go about it. That
Mm.
difference, and that's where the ego can shine up a little bit too brightly, and you have to pull it down. So it seems to me like a difference between what you do and then who you are and how you do it. That's the difference.
And if I may add, in oral advocacy, sometimes opposing counsel or arbitrators would ask us questions just out of the blue, and just sometimes we would just freeze because we didn't prepare for it. And I would see counsel or the witness or the expert just freeze and blurt out things that were just like made up. I would say and advise, just admit if you don't know. Just admit that you lack knowledge in this respect and you're not an expert into it and you're not in a position to say something. And perhaps you would want to ask to be given the opportunity to research more and put that into writing in the subsequent written submissions. There's wisdom and there's much respect that I would give to people who would do that and just admit outright that I do not know about this thing. I do not know the answer to your question.
I think that's humility, isn't it?
Mm-hmm. Mm-hmm.
Yeah. I remember back once in a family court in New Zealand, I was in front of the judge, and the judge said, I'm not accepting your documents. They're incorrectly drafted. And I was thinking, what's wrong with it? But it was there's rules about the margin on the side of the paper. They have to be, I think it was 5 centimeters, so that the judge can write notes in that area. And it was a mistake that the margin was less. And I remember, I can never forget that. I can almost go back to exactly the same spot I was standing in the court when I was hauled up about this technical error. But the room was full of my colleagues from other law firms, and it was super embarrassing. But it was the place to say, to be apologetic, right? And to say, obviously, that's a mistake, and to crawl out of the courtroom. But the way you act in that moment, that wisdom and respect that you're talking about, was super important at that point. Otherwise, if I just argued the point, look, it's only a centimeter that's out. Can't you do that? Isn't it okay to carry on? That's not the important thing today. That would have been super offensive to the judge, and also to, I guess, the reason behind why they have that rule. So that's always stuck with me, and I like how you've brought that out, because it's reminded me of that situation where I could have gone one way or the other. but
Hmm.
thankfully chose a more sort of crawling out of the room with my head buried between my knees. It was very
Hmm.
embarrassing. But you remember these things.
Yes, yes. And I think everyone starts that way, you know? I don't think anyone starts as a junior associate, a junior lawyer already like, too perfect. It's a matter of showing some humility and as you said earlier, showing some vulnerability and just apologize.
Yeah, that was the only thing to do. So, out on the horizon of your own career, what are you thinking you'd like to achieve? Your future dream, perhaps, for your role? It might be in Japan or long term.
Wow.
Yeah, what's your dream? Go for it. If I had a
Yeah.
magic wand and I could give that to you, what would it be?
I would still want to act as counsel for clients in arbitration. But I would see as well that more and there's more traction going into mediation as well, perhaps within the context of arbitration. And then, clients would say, I think it's better now that we go into mediation. And that's been gaining traction a lot in the past. I still want to be, an advocate. I love the adrenaline rush of it all. But at the same time, I know that, all the stress in disputes resolution work may not be sustainable as we grow older. So I would like to get more arbitrator appointments, arguably less stressful, but still doing arbitration work. But you're now the adjudicator or the judge as arbitrator. So it's less stressful, but at the same time, I'm still in the game. That's how I would want myself to be in, let's say, 10 years from now.
Wow. Okay. So before we wrap up with the quick fire questions I've got ready for you, is there
Mm.
anything on your mind from today's conversation, something you'd like to reinforce, or maybe even a final thought to share with our listeners?
Oh, wow. Um, there was a time, and just to give you a brief example, when I was still based in Singapore, and this is my favorite example of how perhaps I started to, hey, no one will give you confidence but yourself. I was just walking around my office building and I met a really senior arbitrator just along the corridors. I was on my way to the toilet. And then he just immediately said, hey, are you from this arbitral institution? Can you bring my stack of awards? Like a lot, let's say 7 sets of 100 pages plus of award to your office. And at the back of my mind, I would say that he might have thought I was the receptionist there. Nothing bad about being the receptionist or the secretary, because he was asking me to bring them all to that office. And I saw myself for the first time. I didn't wear my hair really good at the time. I was wearing flats. Indeed, I didn't look like an arbitrator at all. And one of my mentors was walking along and then said to both of us, hey, you met Earl. She's one of our arbitrators. And immediately, that senior arbitrator who asked me to bring all his final awards immediately apologized. I am so sorry. I am so sorry. I didn't take that personally, but that was a crucial moment for me that I do not look your typical arbitrator. One friend even told me, you're the trifecta of someone who is not commonly appointed. You're Asian, you're female, and you're young. That's how I started looking into myself. And it matters not just how you show up, but it also matters how you present yourself when you show up to people who will be looking for your expertise or wanting to appoint you as arbitrator or as counsel. It's still a perception game at the end of the day. And it matters both, not just your competence, but also how you would want to be perceived by the market.
Earl, that's brilliant. I think you just brought it. I'm so glad I asked you that question. Thank you for sharing that. It's so important, isn't it, to not rest on our laurels in terms of we know what's inside of ourselves and who we are and what we've done,
Mm.
such as being an arbitrator like you were, but we need to present to a certain extent to show that respect to the clients and perhaps even to ourselves and others Not just showing up, as you said, but how you show up is really
Mm-hmm.
important, that executive presence. Thank you for that. That was really brilliant.
Thank you.
Well, let's wind up with some fun quickfire questions if you're ready for it.
Sure.
I often ask people if they have a word or a theme of the year that guides them. So mine this year is reimagine. So everything I've done so far is reimagining through a different lens how it might be, the same things or
Hmm.
different things. So do you have any kind of word or theme that describes your 2025?
I'm more mindful now of self care.
Mm.
Uh, I had some health issues last year. It's okay to be aggressive, be relentless in your work, but at the end of the day, sleep well and do not bring your work into your sleep. I'm more intentional right now. I keep my weekends, away from thinking about the problems of clients. But at the same time, during the week, I know that, all their problems are in my head. But I tell myself, this is your client's case. This is not your case. Sleep and do not think about this. Because I've been losing sleep usually when we have active client matters. That's the theme for me for 2025. More self-care, more intentional and mindful self-care if you want to stay long in the game.
You're being relentless on self-care. I love it. Can you share a podcast or a book that you've been listening to, reading that
Oh, wow.
you'd recommend? Yeah.
Yes, yes. I've been reading recently The Relentless Elimination of Hurry.
The relentless elimination of hurry.
Hurry. I'm still in
Oh,
the middle of it. Um, and I guess it goes with my theme of really being mindful and intentional with not being pushed around in various directions, but being mindful and intentional of how you do things, how you do your job, and at the same time, taking care of oneself, setting up your boundaries as to, so as not to go into health and mental burnout.
yeah, I love
As
that.
to
Mm.
podcast, especially during COVID, I was listening to a lot of Huberman Lab. It's something that's outside of my practice, but it's really good to learn and know more and just be curious about science and how the body works. And I like that.
Excellent. What's your favorite saying? Have you got one in any language?
It's a very long saying about the man in the arena. And I guess this also helped me a lot in building up my confidence in doing arbitration work. So I guess by Theodore Roosevelt and more popularized by Brene Brown, that it's not or something along the lines that it's not the man outside of the arena who has the right to critique or the right to criticize the man inside the arena who is actually doing the work and who is on the accepting end of all the criticisms against him or against her in doing the work.
I love that. So true. Perfect. Well, tell me about one of your hobbies that you've got and why you love it.
I love playing the piano. I'm not a
Oh,
classical piano player though. I love playing the piano and singing to it. So I just love
oh,
to play pop songs and have a song book in front of me and playing pop songs and singing along with it. It's my stress reliever.
well, I was going to ask you if there's something that people don't know about you, but maybe they know that about you, that you like singing.
Yes. For pop songs, I think I'm stuck in the 80s. The love songs in the 80s that I just love to, sing along just in front of family and in front of my husband for their listening pleasure and then play the piano along. But a
Lovely.
lot of love songs, a lot of
Ballads, that kind of thing. Yeah.
ballads.
Yeah.
Yes, ballads. A lot of
Perfect.
heartbreaking songs that makes me like release some pent up emotions.
Love it. Thank you for joining me. It's been an absolute pleasure speaking with you and such a great way to connect.
For sure. Thank you very much for this opportunity. It's been lovely.
So, before we wrap up, where's the best place for listeners to reach you if they'd like to connect, ask for support, or explore more of that relentless self care work that you're engaged in?
Mm. My email address is in our website. I'm on LinkedIn. Yeah, I'm open to,
Perfect.
just giving advice to younger lawyers and all that.
That's really wonderful. Thank you so much. We'll put that information into the show notes as well. So, for everyone else who is listening, please do subscribe and leave us a review on Apple Podcasts. Sign up on Spotify. It sounds like Earl's listening through Spotify there. And, give us some feedback and share this episode with lawyers like you who would really learn some things from this to help their career. That's all for today. See you back here on the next episode. Cheers, kampai, and bye for now.